whose culture emphasizes serving the interests of the United States. These lawyers appear to have believed their primary duty of loyalty was owed only to the political masters who appointed them. What happened to the detainees who were subjected to waterboarding and other harsh CIA interrogation techniques cannot be undone. I think one of the key lessons that we should take away from this is that President Obama and future American presidents can prevent these kinds of betrayals of American ideals by making clear that in their administration, government lawyers must stand for the law and must take into account the broader range of legal and policy considerations that inform decision-making in complex situations. Thank you.
Okay, so is this on or no? I think that one. Okay. So thank you, Liz, and everyone else, all the many student groups who invited me to speak. I'm not going to say a huge amount because I'm just going to limit my comments to the sort of expansive theory of executive powers during time of war under the Constitution that was used in the memos. So essentially, why did this matter? Why is that sort of relevant to the torture question? Essentially, the memos argued that these activities were not torture, and even if they were, the statutes prohibiting them are unconstitutional if applied to persons who are acting under the orders of the president in a time of war, if the president believes that he's ordering someone to engage in these practices in a manner that's necessary to prosecute the war on terror. So basically, this theory was, is employed not just in these so-called torture memos, but in a number of memos that were used to justify violations or potential violations of a whole host of statutes, right? So basically, the idea in the memos was that the president has a broad inherent power during time of war to prosecute that war. And that power is so broad that it actually trumps laws that would seek to limit the president from employing that power in certain ways, right? So the idea is a law that interfered with the president's decisions about how many troops to allocate to a particular region would violate that inherent commander-in-chief power, but also a law that prohibits the president from ordering wiretapping of people within the United States would also violate that commander-in-chief power is the idea. And so with respect to the torture memos, the argument was that the laws at issue, 18 U.S.C. 2340 and 2340A, violated, if applied to these acts, violated the Constitution because they violated the president's inherent powers. And I think sort of relevant to the question of what the role of the lawyer is when giving the client advice on whether certain activities are illegal or might be illegal, it's really interesting to note that these memos don't present the arguments for and against reading executive power in this way at all, right? So there's a really clear argument against reading executive power this broadly that just comes straight from the text of the Constitution, right? So even though the Constitution says that the president is commander-in-chief of the armed forces, it also expressly gives Congress the power to regulate the land and the naval forces. Okay, so that's a sort of big, obvious textual provision that someone might cite on the other side to say that these laws Congress have passed regulating the land and the naval forces were within their powers to pass. But that part of the Constitution is not cited anywhere. It just doesn't appear, that clause, in the August 1st memo that was signed by Jay Bybee. It appears once in a memo that was signed by John Yoo on March 14th, but it actually just appears in a footnote in the memo. And the way that the memo disposes of the argument that perhaps Congress has the power to regulate these activities, regulate interrogations, because of its power to regulate the land and the naval forces, basically it disposes of that by saying correctly that in a Supreme Court case, ex parte Quirin, the Supreme Court didn't deal with the issue of whether Congress could use that power to regulate military commissions. Then it cites to an OLC memo written by members of the Bush administration, I think by the same author actually, it just cites to that memo to say, but we've decided that Congress doesn't have the power to regulate military commissions. And if they don't have the power to regulate military commissions, then obviously they also don't have the power to regulate interrogations, because that would also sort of fall within the commander-in-chief's core military power during time of war. So it's just, basically a 3-sentence footnote. This is the analysis. There's no attempt to consider whether regulating a military tribunal is factually different than regulating the way that people are interrogated or regulating these extreme versions of interrogation. There's no sort of discussion of the facts at all to explain why would this type of regulation sit at the core of the president's commander-in-chief power, when presumably some other regulations don't, right? The power to regulate the land and naval forces has to mean something. So there's something Congress could do that wouldn't violate the president's commander-in-chief power, and there's no attempt to make that distinction. Similarly, the memos don't make any attempt to cite to case law that's not good for the argument that the president has these really broad powers. So there's a really famous case called Youngstown, which almost every law student who takes a constitutional law course that covers executive powers in time of war reads. It's usually the sort of primary case in that section in the book. And that case is not even cited in this August 1st, 2002 memo. And normally if there's a case that you don't like and you're writing even a brief, let's say you're trying to defend someone who had engaged in these interrogations, you would still have to cite the Youngstown case and explain why the situation of interrogating detainees is different from the situation in that case, and why we should read executive powers more broadly than the Supreme Court did in that particular case. So none of this sort of reasoned presentation of both sides, putting the situation into factual context so as to perhaps limit the sort of circumstances in which someone who reads the memo might think that they had power to do what they wanted. None of that was really engaged in. And if you just try to put yourself in that situation, I think you can see why this just doesn't even pass the test, the laugh test of good lawyering. If you had a client who came to you and said, I'm thinking about doing something, is it illegal? You wouldn't write a memo when you have cases like Youngstown out there and text like you have in the Constitution that says Congress has the power to regulate the land and naval forces. You wouldn't write a letter to that client leaving all of those things out and saying, yeah, go ahead, it's not illegal, right? You would tell them that they're treading on really dangerous ground at the very least. So I think, one can disagree on whether the president has broader powers during wartime than not during wartime, but I think everyone can agree that these memos did not present the issue in any kind of objective or fair light that would be useful to someone who wants to use that analysis to decide whether to engage in the interrogation or not.
So I'm going to focus I want to get to in just a couple of minutes 3 legal ethics issues that are raised by the conduct we've been talking about, 3 issues that I think should be brought to some appropriate form and resolved definitively. In other words, we should press forward, we should reach a resolution on these 3 ethics issues I'm going to raise in just a minute. Now, we have many regimes for regulating lawyer behavior. We could have criminal prosecutions, both domestic or international. I won't be discussing those. Civil liability, we currently have in San Francisco, and you can go see some of the hearings, the lawsuit by Jose Padilla, sometimes pronounced Padilla, for civil liability against John Yoo, by a fellow who's been convicted. That's on appeal to the Ninth Circuit. We could have academic discipline. I won't be discussing that. And then we could have professional discipline, or what I'll call state bar discipline. That'll be my focus. There's 2 kinds of state bar discipline: independent prosecutions and reciprocal discipline. Let's start with the independent prosecution. That's when the state bar kind of looks like a criminal prosecutor, does its own investigation, puts a case together, and tries a lawyer under the ethics rules, and the ethics rules kind of look like a criminal statute in that sort of a proceeding. In this case, the ethics rules that would apply appear to be the District of Columbia rules, but yet they're standard rules. There's no wrinkles, interesting wrinkles, so it would be the DC rules. But who would try it? Oddly enough, for historical reasons I won't get into, the DOJ does not have jurisdiction over a lawyer no longer employed by the DOJ. The District of Columbia will not prosecute. It's the Pennsylvania State Bar, of all people. That's where John Yoo has his professional license. So presumably it would be the Pennsylvania Bar applying the DC rules if they're going to go down this independent investigation.